Welcome to Switch Moments, brought to you by Brave Switch and Young Wealth Management and Estate Planning Company Limited. At our last session, we talked about the difference between real estate and estate planning. However, during that presentation, we promised that in our next video, we were going to explain the concept of wills. We're going to go into details of what a will is about. But during this presentation, we'll be looking at the meaning of a will, what's a will. We'll also look at the requirements of a will, what makes a will valid, the kind of properties, assets that you can put in your will, and we'll also be looking at testamentary trust. So we'll be explaining that because it derives from a will. So what is a will? A will is a legal document that is written by an individual, giving his instructions as to how his properties should be distributed or transferred to his beneficiaries. So there are certain things that makes a will what it is. So you look at a will, for instance, there's a word called the testator. The testator is the person that writes the will. That's the maker of the will, is the testator. Then there is also what we call executors. The executor is the person or the persons appointed by the testator in the will to fulfill or to implement the instructions that he has left in the will. So for instance, Mr. A is the maker of the will. He appoints Mr. B and Mr. C that in the event that I pass on, please ensure that what I have stated in this will are what executed. So that is the role of the executor. The law allows you as a testator to appoint executors in your will. But interestingly, if you decide to make a will, at the point of enforcing the instructions in your will, your executors would have to pay 10% of the total value of your estate, of your properties, to the probate registry. So the probate registry is the registry of a particular state high court that is responsible for probate matters. That is where your will is lodged. 10% of your total estate value must be paid to the probate court before your executors can actually have the mandate to execute the will. An interesting thing about a will also is the fact that a will comes to life upon the death of the testator, upon the death of the maker of the will. So you can write a will today, in the next 20 years, in the next 25 years, in the next 30 years, the will is still valid and still there, but nothing can be done about that will or to that will until the maker of the will dies. So we say generally as lawyers that the will comes to life upon the death of the testator. Yes, so this is a very important part that must be understood by everyone who intends or desires to make a will or use a will as his estate planning device. We want to look at the requirements of a will. You know, in making your will, what do you really have to consider? There are a few things that we've highlighted here. So for instance, the maker of the will, under the law, the maker of the will must be an adult. So you must be at least the age of 21. But in Lagos State, the required age is 18 years. So once you attain the age of 18, you can make your will. But generally, 21 years, you can make a will in Nigeria. Particularly to Lagos, 18 years is the required age. Then you must have testamentary capacity. What we mean here is that you must be of sound mind. You must understand the action that you're taking. You must understand the fact that yes, you are making a bequest of your properties. You are giving instructions regarding your properties, who gets what goes to who, and all that. You must understand the implication of your actions. Once you have a condition that fetters your ability or hampers your ability to be able to understand what you're doing, the law says that you cannot make a will. We also said that the testator must not be under undue influence, so he must not be under any form of duress. What do we mean here? In making your will, nobody must put you under pressure. A situation whereby somebody says, I'm going to lock you up in a house and you have to write this and write that, puts a gun to your head and says, give me so and so assets in this will. The law says that once that information comes out, that will is invalid, because the will was not voluntarily done. It means that you didn't make that will out of your own volition. It was not out of your own free will. Somebody compelled you to make that will. So that would actually vitiate or affect the validity of that will, and to make it highly contestable in court. You really want to avoid things that will make your will contestable in court. Those are the things that will leave the will in court for years, and before the court will make a decision. We'll be moving straight on to what makes a will valid. If you look at the will, the law has already made provisions for things that must be done before a will can be valid. First is that the will must be in writing. The will must be written down. So as a testator, there are certain instances whereby, yes, the will need not be in writing. Look at, cases of men at war, air hostesses, people working in the air and all that. Yes, but that is not the situation we're looking at right now. But we're saying that generally speaking, that your will must be in writing for it to be valid. The will must be signed by the testator. So the maker of the will must sign the will. The law also requires that for a will to be valid, that there must be at least 2 witnesses present at the time that the maker of the will is signing the will. So you do not have the witnesses coming at different times, because the maker of the will cannot sign the will twice. So both the witnesses must be present at the time the maker of the will is appending his signature to the will. And the witnesses must subscribe or attest to the will. They must sign and write down their particulars on the will after the signature of the testator. So these are things that must be fulfilled before a will can be valid. Now let's quickly move on to things that you can actually capture in the will. So you talk about land and buildings, you talk about cars, furniture, your personal effects, your clothes, your gold, your watches, your shoes. All those are your personal effects. Can be what? Can be put in a will. Your rights in certain transactions can be put in a will. Equities, shares, stocks, even debts in terms of what you owe to people can be put in the will. You can also look at your retirement savings account. Your pension can be put in your will. A lot of other things can be put in your will. So it is not good whereby you're drafting a will and you think some things need not be in the will. Everything you have in terms of your properties can, or better put, should be put in the will. The last on the list that I will be talking about is the concept of testamentary trust. So a testamentary trust is a trust that was created in a will. You can create multiple trusts in a will, but there are cases where people use testamentary trust. The most rampant is where you are writing a will or you're making your will and you have minors, you have children, young children who cannot even take care of themselves. So you want to make sure that yes, you have given this to them, certain properties and assets to them, but they don't have the capacity or the ability to be able to manage those assets by themselves if anything happens to you today. So you want to appoint certain persons as trustees to make sure that whatever you've given to them, the trustees hold those properties for them until they become of age or until they get to a particular age that you would have stated in the will. So yes, is a will a good estate planning device? The answer is a clear yes, but you must make sure that you consult with professionals who understand what estate planning is and how to use a will to capture your wishes and your desires in terms of your estate. Brave, Sweet and Young, we are an estate planning company. We're professionals and lawyers who have in-depth understanding of what estate planning is and what the concept of a will is. We can help you write your will. We can help you structure your estate such that everything you own can be captured and left for your loved ones. Thank you for joining us on this video. We hope to see you next time.